If you've got any questions concerning the content of the work, or and I say this from the very beginning, I assume that we are dealing mostly with advocates and attorneys or people in legal positions, and we know that things can arise overnight and then you run short of time. You are then welcome to send me an email and ask for an extension, but you must have a valid reason. Don't just do it for the fun of it. I've been teaching for nearly half a century. So I know when students take chances, but if there's any issue or whatever, you are welcome to email me. For administrative matters, of course, you liaise with Grace Makuru, whom I think you all have met some or other way. Okay, let's talk about some general matters. You have a schedule on your website, and there it will be indicated when you have to submit what. It will also be indicated when the webinars will take place, and it will also indicate when Bonnie will be available if you want to email her or ask a question. Otherwise, you can email me anytime, and I will respond as I get the emails. Then under announcements, it depends. Bonnie sometimes do it under extra reading, sometimes under announcements. So go to all of that and check. When I come across a case that I find interesting, or a journal article, or maybe something in a book, then I will send it to Bonnie, and Bonnie will upload it on your website. These are just for extra reading. These are extra material. Okay, let's talk about that. You have enrolled for this module, and I assume it is to know a little more about medical law. In other words, we are not a first year class and you just want to get a qualification or just want to pass and you will do everything possible, even cheat or whatever. This is not the case. This module is dependent on you. It is dependent on you. We're going to expect you to do a lot of reading yourself. In other words, this is not just to pass. This is not just to get a qualification. It will depend on you whether you are going to learn anything or not. And that is why I give you extra information. But it is up to you to go and read it, think about it, and maybe ask questions if you want to, but you will not be tested on the extra material. So please do not think that we are expecting too much of you. We're giving the information, but you will not be tested on it. You will have to write a test 1. That test is based on the theory, which is online. In other words, all the outcomes that we are referring to, and I will have it on a slide just now, that is the only work that you study for test 1. So for test 1, you do not study the extra material that we give, nor the portfolios or the acts that form part of the acts or the cases that form part of your activities. That is not relevant for test 1. Test 1 is absolutely only the theory, the study material that you got for this module. You have to go through it on your own. And once you feel you are ready, but check the schedule. When is test 1 due? Because after that date, we cannot accept it. So at your own time, when you feel confident that you know more or less what the work is about, you can do test 1. And that will contribute 20% to your final mark. I'm just interrupting myself quickly to take a sip of water and to say, please make notes while I speak, and then afterwards you can ask questions. I've got ample time. I'm not in a hurry. So just make a note of your question. I prefer to do my presentation and finish it so that those people who are in a hurry or do not have as much data as the others, that they at least have the information. But if you've got any question, afterwards I will switch on my camera and we can interact, and you are welcome to ask as many questions as you would like. So, okay, just to summarize and go back, test 1 is only based on the theory and the study material provided to you by LEAD. No extra material is relevant. You will go through the theory yourself, and once you feel ready, you will do your test 1, which is 20% of your final mark. Then on a weekly basis, you will receive activities. Activity 1, 2, and 3 will make up portfolio 1. Activity 4, 5, and 6 will make up portfolio 2. In other words, you get the activity, but you do not submit it in that week. You wait until you've done 3 activities. Then you combine it into a PDF format and then you submit it. And please remember to have a sort of a title page where you just put your name and your number, because sometimes people just submit and then we do not know whose work this is. So have a title page with your name, your surname, and indicate to us that is portfolio 1. And then you number your questions. Question 1, 1.1, 1.2, question 2, question 3, so that we at least know how to mark your work. And this is a warning, and you can see that I've got a lot of exclamation marks there. Plan your time. And every year and every semester and every new group that I have to talk to, I say to them, plan your time. And I think the majority of students think, oh, she's just talking. You have to plan your time. We are expecting a lot of you in a very short time. So you have to keep rolling with us. When you get your activity, try to finish it that week. Next week, the next activity, finish it in that week. The next week, the third activity, finish it in that week. Then your portfolio is ready. Once you fall behind, it is very difficult to catch up, because we expect a lot of reading from you. In other words, the questions are not difficult. At the end of the day, the activities are like a comprehension test when you were at school. You have the case, you must read the case, and you must answer the questions. But the reason we do that is we force you to read the case. We specifically force you to read the case as you had to read the comprehension test at school, and then to answer the questions. But some of these cases are quite a few pages, and that's why I say you might run out of time. You have to plan your time. You are allowed as students to talk to each other. You can, for example, on the forum say, can someone help me with this, or how should I understand that? But at the end of the day, you have to do your own work. And then I just say, never give up. You've paid for this module. I don't know who paid for you. Either you paid for yourself or your company paid for you. So don't give up. Stick in there. If something happens, email and we will try to help, because we want all of you to get the qualification, because you've spent money and you've spent time. So never give up, rather talk to us and we see where we can help. So I said that test 1 is 20% of the mark. The other 80% is then your portfolios, both portfolios. So it's 6 questions of 50 marks each, and then we work it back to 80%. One of the questions in the first portfolio is only 25, but then we double it up for a mark out of 50. So what do we look? What do we want in your activities for you to do well? And by the way, just a side note, if you pass this module and if you pass it well, you must be immensely proud of yourself, because this is not easy work and we expect a lot from yourself. We give very little input, so everything is on your shoulders. So when you pass, and when you pass with a distinction, I congratulate you even now, because then you really, really, really deserve it. As I say, the work is not difficult. It's not difficult at all. It's just a lot of work. Okay, the questions for the activities. It is broader than the study guide. In other words, I assume, or me and Bonnie assume, that you can all read. So it serves no purpose to ask questions from your study material. That is tested with test 1, which is multiple choice. So the activities we give to you are broader than the study guide. It is cases where the principles in the study guide have been applied. Plus, it is in every case has been selected to bring something very important to your attention, which we think you might find in practice when you practice as a medical law consultant or a medical law attorney or a medical law advocate, or you give legal advice to hospitals or medical companies. So we want to bring certain things under your attention so that you can see how the courts dealt with it and how the courts interpreted the acts and how the courts handled the matter. So that will also guide you in your future practice. So activity 1, 2, and 3, which makes our portfolio 1, which must be submitted as one document, is due on 13 April, but please keep your eyes on your schedule. And then activity 4, 5, and 6 is portfolio 2, and that must be submitted by 11 May. And once again, I say, ask if you need help. I know I got an email from a student who said that he is from another country. I'm not sure, Lesotho, Botswana, even Namibia. And those people sometimes find it difficult to find the case on which the activity is based. But I am a mother and I have 2 grown-up sons, so I know. So my motherly heart have also given Bonnie the cases. So you will be provided with the case on which you have to answer the questions. In other words, you will not have to go and find the case yourself. If something goes wrong and you can't get it from the system or whatever, send an email and ask. But you will be provided with all the cases that are relevant for the activities. The last activity, activity 6, is a case concerning the HPCSA. There's a lot of Afrikaans quotes in that case. And I apologize for that, but that is how the case was reported. But not one of the questions referred to those phrases or quotes in Afrikaans. So if you do not read the Afrikaans parts, you will still understand the case and you will still be able to answer the question. So don't worry about that. You will also see that one case that you're going to receive, I scanned and did not get from the internet. Therefore, there's a lot of my sort of notes and underlining on that case. But that case is not available on the internet anymore. And I wanted to use that specific case. So I just apologize for the neatness of that case, but I think you will see what is the message I want to convey through that that specific case. But as I've said, ask, ask if you need clarity or if you need help. Okay. Then how do we assess the portfolios? Because it's 80% of the total number that you're going to get for your final mark, it is quite important to put the effort in the portfolio and not to just rush it down. You do not have to reference. Okay, so you do not have to reference. As I've said, you treat the activity as a comprehension test. So all the answers will be coming from that prescribed case. So you do not have to reference. It is more important for me that you know the content and the principles in the case than whether you can reference. That is for something else, and you will be taught that in a different module. So what are we testing in the portfolios? First of all, did you understand the question that we asked? And did you do what was expected of you? Here I can give a hint. Always look at the marks allocated. And the marks allocated will indicate to you what is expected of you. In other words, if the question is discuss the events that gave rise to this medical negligence case, and it is 20 marks, then you must go in detail from what happened in that case. Then we want to see whether you understood the principles that we tested. In other words, was this a criminal case? Was it based on prescription? Was it based on cerebral palsy? Was it based on an organ transplant? Whatever the case may be, we want to see whether you grasp the principle that was tested. And then generally a little bit subjective, we look at whether you've put in an effort and whether you enjoyed what you did and whether you are proud of it. In other words, your whole presentation will tell us you enjoyed it or you just rushed to get it done. Okay, now the study material that you receive online. First of all, I want to say that it is not original work and that I compiled the theory, but I used the following books. The first one is Carstens and Peermyn, Foundational Principles of South Africa. It is from LexisNexis, that is the publisher. It was published in 2007. Unfortunately, that book is not available anymore. So you will not be able to buy it from LexisNexis. But Professor Carstens from the University of Pretoria is busy updating the book, and a new edition will soon be on the shelves. But go to your social media, to your Facebook, and ask whether there are people with a Carstens and Peermyn, and try to buy it secondhand because it is extremely detailed with all the information you will basically ever need in medical law. But as I've said, unfortunately not available anymore. See if you can get your hands on a second-hand copy. Then there's another book which is also very good and very helpful, and it was written by Dye and McQueen Mason. The title is Bioethics, Human Rights and Health Law, Principles and Practice. It was printed by Juta. There is a 2011 edition, but they have updated it, and there is a new edition of 2020. Very nice book, very useful, very easy to use as a reference material. If you are more into human rights, you can look at the book of Moodley, Medical Ethics, Law and Human Rights, a South African Perspective, and it was published by Van Schaik in 2011. Then what I also would like all of you to have on your desk as a sort of a very quick reference is McQueen Mason and Dada, The A to Z of Medical Law, and it was a 2011 edition. That is to quickly go and find answers, and it will give you guidance on where or what to research further. So it's very nice to have it next to you on your desk as a quick reference. Then van der Heever and Lawrenson, Expert Evidence in Clinical Negligence, 2015. You cannot have a medical law practice without that book. Because as we carry on in the next webinar, you will realize that you win or lose a case by the expert evidence. And that book is excellent. It explains everything, how to negotiate with an expert, which forms to be signed, how do you get the records from hospitals or private doctors, how do you prep your expert. Excellent, excellent book. Not that cheap, but it's worthwhile having that book. The next one is John Sainer, SC, Senior Counsel, Medical Malpractice in South Africa. LexisNexis, that one is very expensive. It's loose leaf, so they update it. It has been updated in 2020. It was again updated this year. So that is an excellent loose leaf file to have on, because that is everything concerning medical malpractice in South Africa. And then if you want to know more about the quantum of damages or how to work out the quantum, then you can look at that book of Potgieter, and it is a 2019 edition. And then, of course, always remember that the Health Professions Council of South Africa, the HPCSA, they also have booklets as guidance, and those are accessible over the internet if you just go to the website of the HPCSA. So you will see on this slide that those that I have bolded, those that in the dark black, those are the most important and which I will suggest that you get hold of if you practice in medical law. Okay, so this is the outcomes that this module have. And those are the headings and the work that you have to study for test 1. In other words, this is the study material that you will have on your website. So we're going to start with the Constitution and its impact on healthcare and access to healthcare. Then the legal position of the hospital-doctor-patient relationship. The third one is the crux of this whole module, and we will devote quite a lot of time to that. Medical negligence. How do we test it? How does it impact? How do you go about proving that, etc.? And then the grounds of justification. If you are on the other side, in other words, you are not the patient, but you are acting for the doctor or the hospital, what could possibly be your grounds of justification? And then the influence of legislation on the practice of medicine, which is a few pieces of legislation that I will refer to. And then in your study material, there are practical exercises. You do not have to do those practical exercises. We are not going to assess it or give you the answers. Those are just examples to keep you thinking and to show to you what a possible medical negligence case can look like. So these are the topics that are relevant for test 1, and those topics are the theory that you have to study. And as I've said, once you feel comfortable, then you go for test 1. That will be 20% of your final mark. Okay, so that has been general background. Sorry, I'm just drinking water so that you know more or less what is expected of you on the administrative side. But now let's go to medical law or medical negligence. Remember that medical negligence is just a part of medical law. Medical law is much wider. But our emphasis in this module is on medical negligence, although we're going to expose you to other topics as well. And I think medical negligence is one of the most enjoyable subjects in law. And why do I say that? Of course, you can hear I've got a passion for medical law. But medical law per se is what? It is basically knowledge of the law of contract, knowledge of the law of delict, knowledge of constitutional law, law of evidence, sometimes labor law, and a huge part of ethics. And all of that comes together in medical law. That's why medical law can never, ever be boring. I know that my colleagues at the University of South Africa always ask, why do I publish so much? And then I tell them, because there's so much to say. Medical law is also dynamic. It changes nearly on a monthly basis. Why? Because technology change and the law are sometimes behind what is possible in the medical sphere, and then the law is not there. Although the principles for medical negligence stayed the same through the ages, but nowadays we've got things like in vitro fertilization, surrogacy, a lot of different fields, and one must evaluate whether the law fell behind or whether the law is anticipating what can happen, etc. So medical law, I can guarantee you, will never bore you because there's always another angle, another view, or another perspective. But I want to start with a quote, which I took from a case. It was Mediclinic versus Vermeulen. So you immediately see that it is private sector, because Mediclinic is a company and Vermeulen is a natural person. So this happened in the private sector and it went to the Supreme Court of Appeal. But there the judge said something which is very important. We should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than the good of their patients. Initiative would be stifled and confidence shaken. A proper sense of proportion requires us to have regard to the conditions in which hospitals and doctors have to work. We must insist on due care for the patient at every point, but we must not condemn as negligence that which is only a misadventure. And I want you never, ever to forget this. Everything that goes wrong in a hospital or with a doctor is not necessarily negligence. In other words, the doctor can do his best and still the patient dies or loses his legs or there's septicemia or whatever. Everything is not negligence. So in this module, you are going to be taught how to determine whether there was negligence or not. But sometimes people go to hospital and the slightest thing that go wrong, they want to sue the hospital, they want to sue the doctor. And every misadventure is not necessarily negligence. And yes, it sounds now as if I'm on the part of the doctors or the hospitals. No. Just with every profession, architects, auditors, engineers, there are good people and there are bad apples. So yes, things go wrong. In a hospital, doctor-patient scenario, life is important. So life, if something can go wrong, someone can die. That is the sensitivity, and that doesn't happen with auditors or engineers. But remember that everything that goes wrong is not necessarily negligent. So just keep that in mind. And just another thing that I'm just thinking of, those of you who joined this module and think you're going to learn how justice should be done, I'm surprised medical law is not necessarily always justice. It's not necessarily always justice because money also comes into play. We've got a public sector, we've got a private sector, we've got a shortage of resources, we've got a shortage of doctors. So justice is not always done. Also keep that in mind. Okay, but why did you enroll? I think it is because you are aware of the number of things that goes wrong, either with doctors or in hospitals. So this is just a sort of indication of the kinds of claim. You can see it's quite outdated, but I think it encapsulates more or less how money is spent. At the bottom there, Baragwanath's total claims were 420 million rand. So we're dealing with huge amounts and things go wrong. As background, in order to empower yourself better, remember, I can only give you a piece of the cake. The rest you must do yourself. This is not for test one, and it will not be tested. This is self-study to broaden your scope. I want you to go to the Law Reform Commission's website. So I've given it there to you, https://lawreform.justice.gov.za. And I want you to find paper 33, project 141. That was the last paper, but then a new one came. What is excellent about that paper? It indicates to you how long medical negligence cases take. Some cases take 10 years, some 16, some 4, some 3. So you will never be rich overnight, starting to be a lawyer focusing on medical law, because these cases take forever to settle because experts are involved, etc. So go to that paper because that is a lot of extra information. Plus, at the end, you will get a list of nearly all possible medical law cases in South Africa. So that paper 33 is really, it will help you immensely. And then there's a new project paper, paper 154 of project 141, and it is medico-legal claims. This document is now in the open for comments. In that document, they propose that medical negligence cases should be resolved by way of mediation instead of either criminal prosecution or civil prosecution. So read that. It is extremely interesting. It gives a lot of statistics of the amounts paid out in medical legal claims, etc. So that will also help you. Remember, you're not going to be tested on this. This is to empower yourself with knowledge, that you go to those documents and you read it. Then you can also go to the Corruption Watch website, and there's a document, X-ray, the critical state of the health sector in South Africa. And that will horrify you, but there you will see that things are not well in our health system. I'm not necessarily saying everything is negligence, but things are not very healthy in our health sector, and you will get a lot of information there. But once again, these are extra reading to empower yourself to have more knowledge should you endeavor to become a specialist in medical law. You are also welcome. I can't remember the cutoff date for comments on that paper 154, So you can go and check if you think it's necessary to give comments. And I'll refer back to this again when we discuss criminal liability of doctors. I'm going to refer back to this again, so keep it just at the back of your minds. Okay. So by way of introduction, some people talk about healthcare law, some about medical law, some about medical negligence. Healthcare law is just a bit wider than medical law per se, but it depends on what books or what journal articles you are reading. They basically use the two interchangeably. The same with medical malpractice and medical negligence. Although we as experts feel that malpractice is more if you um, if you cheat or you claim too much from the medical aid for procedures that you did not do to the patient, that is malpractice. Whereas negligence is where you performed an operation and the person eventually bled to death. So it's a small nuance difference, but not very major. Just be open for it when you read wider than South Africa, or when you read even widely in South Africa, that people use the words healthcare law, health law, medical negligence, medical malpractice. But read the context in which it is said. Then you should know that we in South Africa, we still do not have the national health insurance. It is envisaged for 2026. I don't know whether that's going to happen because no one has foreseen COVID. And I think things stood still for a little bit. So until 2026, at least until then, we still have a public sector and a private sector. That is the first thing that you must take home from tonight. What is the difference? Because there is a huge difference. The public sector. South Africa is one nation with 9 provinces. Every province has a MEC, a member of the executive committee or a member of the executive council. It depends from province to province how they name these people. But each province has someone in charge of their healthcare in that province. But we also have a national Department of Health. Now, when the budget, sorry, I just quickly want to mute all. Please, people, mute yourselves. Okay, I've muted all. Okay, so but the public sector, the finances come from the national budget. Then a certain amount goes to the National Department of Health. And then portions go to the 9 provinces. And the MEC in a province must then allocate the money to the hospitals and the clinics in that province. But they get one amount. In other words, they must use that amount for salaries, for medicine, for resources, for beds, for bedding, for medicine, for paying the cleaning staff, for paying the food in the hospital. Everything must come out of that budget per province. Now, when there is a claim of negligence and the applicant is successful, then the money, the damages awarded to that patient must also come out of that budget. And that is the problem. In KZN, at some stage, there were no money left in the Department of Health for that province because they had to pay out everything for negligence cases. And some people even went and attached the desks and the computers of the people working for health in that province. So there's a huge, huge problem. And remember that when you read that law reform paper, which recommends that there must either be a cap on the amount that you can claim for medical negligence, or that it should be solved or settled through mediation in order to lower the legal costs at least. That is all the problems in the public sector. But now if something goes wrong at a clinic or at a public hospital, then you will sue the MEC of Health, or you will sometimes see that some cases even refer to the Premier. Why? Because everyone in the public sector are working for the state. In other words, they are employees of the state. And the principle of vicarious liability, I assume that most of you know this principle. Vicarious liability means the employer is responsible for what the employee does if the employee acted within his scope of appointment. So if a nurse or a doctor does something wrong in a public hospital, then by way of vicarious liability, the member of the executive committee or executive council for health for that province is ultimately the responsible person. It will not help to sue the doctor or the nurse because they will not have the money to pay, and usually medical negligence claims are millions. So it will not help to sue the doctor or the nurse. So because of vicarious liability, you sue the employer, which is the state. So you sue in your province the head of the health for that province. The private sector is different. The private sector, every doctor or specialist work for him or herself. Then we have private hospitals, for example, Netcare, Mediclinic, Life, Busamed. All those are companies. They are private companies with shareholders. And the doctors working in that hospital are not employees of the hospitals. They are independent contractors. So if something goes wrong in a private hospital, you will sue the doctor in person and he will have insurance. He should have insurance, and you will sue the private hospital. And then the hospital must come and indicate that they should not be a party because it was purely what the doctor did and not something in the hospital. The nurses are a little bit more complicated. In the private sector, the nurses doesn't necessarily work for the private hospital. They can be there because of a labor broker. In other words, they work for a company who places nurses at private hospitals where there is a need for them. In other words, if you want to accuse a nurse of negligence, you will have to sue the nurse in person as well as the private hospital. And then the private hospital should come and indicate that the nurse is not their employee, but is basically working for this company, which is a labor broker company, and then you sue them as well. So with nurses, it is a little bit more complicated. Some hospitals do have their own nurses as employees, but some don't. But every person that is registered by the Health Professions Council, in other words, the anaesthetist, the doctor, the physiotherapist, the speech therapist, all those people are independent contractors, and you must sue them in person. Okay, so that is the difference between public and private sector. I'm just going to go a little bit further. In the public sector, because the doctors and the nurses are employees, they have no choice who they want to treat or not. In other words, because they are employees, they must treat any person. according to their contract of employment. And because it is constitutionally valid to have an abortion, according to the Choice on Termination of Pregnancy Act, the public sector cannot refuse to perform an abortion. If the specific doctor has either religious or cultural issues that he or she does not want to perform an abortion, they have the duty to refer the woman or the girl to someone who will do it, but they cannot just plainly refuse. They have to find someone who will do it because it's the law of the country and because in the public sector they are employees. The private sector is completely different. There, a doctor or a specialist can decide who he or she wants to treat and who not, as long as they do not discriminate against any of the rights in the Bill of Rights. In other words, a doctor can say that he will only see patients on Mondays, Wednesdays, and Fridays, and he only wants to work with abdominal pains, for example, and that will be fine. But he cannot in the private sector say, I am only going to treat whites or Indians or blacks for that sake. So no, that is not allowed. He can also not say he's only going to treat women, because that is discrimination on the basis of sex or discrimination on the basis of race. But a private doctor can choose. In other words, he can just tell the patient he does not have the expertise and the patient must go and find someone else. Or he can decide on Wednesdays he will not see patients. He has that liberty because he's working or she's working for him or herself. But in the public sector, they are employees. So there's a difference. In the private sector, sorry, I'm just drinking water. In the private sector, in other words, you can refuse to do an abortion. You can refer the girl to someone else. In the public sector, you can refuse, but you must refer the person to someone else because it is part of your employment. Okay, I'm talking a lot and I'm hoping that you make notes, and remember, you are more than welcome to ask and interact with me when we are finished. Okay, so the Constitution, we're going to start with the Constitution. So at this stage, I'm just saying the Constitution is always in the background. So whenever a client comes to you, something went wrong, you will first check whether there was any violation of the Constitution. And I'll go into a little bit more detail just now. So you always start with the Constitution, and remember, what is also important is that the jurisdiction of the Constitutional Court in South Africa has been widened. It used to be only specifically if there was a violation of the Constitution, but nowadays they entertain any case if it is something constitutionally and in the public interest. And I'll come back to this when I will be referring you to specific cases. But the jurisdiction is now much wider for the Constitutional Court. And really my heart go out to those judges because I think they work extremely hard. But we'll come back to that. The next thing, as I've said, the one thing that you have to take from tonight is that we have a public and a private sector. The next thing that you must never, ever forget from tonight, and that is the basis. That is the very basis of medical negligence claims. If there's no damages, there's no claim. And I'm going to try and illustrate this to you with an example. If I have a son of 19, he is a student, he is living with me, he doesn't have a wife nor children, so he's completely independent, he doesn't earn money, he doesn't pay rent, he is still as a child in my house and he's studying. One night he goes out, has a little bit too much to drink. There's an accident. He's taken by ambulance to the hospital. And unfortunately, in hospital, because of the negligence of the doctor, my son dies. It is blatant negligence of the doctor. So you can see it, it's clear. Unfortunately, I will have no claim. I will have no claim. Because what damages did I suffer? My son did not support me. My son did not give me any money. So I cannot prove what is my loss. Of course, my heart will be broken. Of course, there will be emotional trauma, but that cannot be proven. That cannot be quantified. So there will be no claim. Yes, the doctor that was negligent, I can report him or her to the HPCSA where they will be disciplined, hopefully, but I will not be able to institute a civil claim. This is the sad part of damages of medical law, and this is the part that a lot of students have problems with to understand. I'm going to give another example. If my same son, 19, completely dependent on me, in other words, not earning a salary, doesn't have a wife, doesn't have children, and he's in an accident and he goes to hospital, and because of negligence, he is paralyzed, then we can institute a civil claim for millions of rands, because now we can prove damages. We can prove his loss of the immediate life, can prove that earn a huge salary being a professional athlete, whatever the case may be. Then damages can be quantified and we can claim. I say again, this is the sad reality of medical law. If you cannot prove damages, you have no claim. I'm going to give another example. Young husband and wife, two small children in primary school. They decided they do not want to have any more children. So she goes into hospital for a laparoscopy in order that she cannot conceive anymore. It is a minor operation where they just go through your navel entrance and they blow up your stomach and they bind down your ovaries. So no need to cut, nothing. She didn't even tell her mother she was going through the operation because it's so minor, and it usually takes maximum of 40 minutes. So they drop the children at school. She and her husband goes to hospital. He sits outside and wait. The next moment, there is absolute pandemonium. End of story. She bled to death. So this young man is devastated, and of course, he wants to sue the doctor because something went wrong. Something went wrong. She was not supposed to cut open the abdomen. Why did she, and why did his wife bleed to death? Unfortunately, he earned about 1,000 rand more than his wife. Therefore, he is immediately seen as the breadwinner. So he cannot prove that he lost any damages because he's the breadwinner. The two children can possibly claim for the part that their mother contributed to the civil union, to the household. But that will, because they were lower income, that 1,000 rand. And no attorney will take a case because the legal cost, even if it's taken on contingency, the legal cost will be triple that amount. And therefore, nothing can be done. They lost a wife, a mother, but no damages can be proven, there's no claim. Keep this in the back of your mind. It sounds difficult, but as we work through the cases, you will see if you cannot prove damages, it's not worthwhile instituting a civil action. Of course, you can go and report the individual doctor to the HPCSA, and they will follow a process which you will also know by the end of this module. Why do I say that? Because we go to, you have to prove all the requirements for a delict in order to be successful with a case. Now, I hope those of you who has done the law of delict can still remember what are the requirements for a delict. There should be conduct or an act. It must be wrongful. There must be fault, and fault can either be intentionally or negligently. In our module, we will focus on negligence. You will have to prove causation, that the act led to the damages. So whenever you have a case in front of you, and we will go over this again and again, you must evaluate. Did someone act? Was it wrongful? Was there negligence? Because I don't think any doctor will act with intention. Can you prove causation? In other words, that what doctor or the hospital did, is that closely relevant to the damages? And then, of course, can you prove damages? Okay, so what is the difference between claiming damages after a breach of contract or under a delict? So this is the third thing that you must remember tonight. The first one was that we live in a public and a private sector. The second one was if there's no damages, there's no claim. If there's no damages to be proved, there's no claim. And then the third one is, what is the difference between claiming damages after a breach of contract or under a delict? If you claim for alleged medical negligence, you can either claim on the basis of delict or you can claim on the basis of a contract. Because the moment a doctor assumes the duty to care for a patient, there is a contract between them. Or if you go to hospital, you will sign all those admission forms, there's a contract. A delict is when it is expected that the person, the doctor that looks after you, should do that to the best of his ability, a duty of care. But when you decide on which basis to sue, there is a fundamental difference between claiming damages either under delict or under contract. And remember, in medical law, you can claim either on delict or on contract, or you can go on both. There's no problem. You can go on both. The majority of cases is done, I'm just muting, is done on the basis of delict, but nothing stops you from doing it on contract. The difference between the two is, on contract, you can only claim patrimonial loss. In other words, real loss. In delict, you can claim non-pecuniary damages. In other words, pain and suffering. Remember the example that I used, my son being paralyzed. He will be able to claim a huge amount of money for emotional shock, emotional trauma, everything that he lost, all of that. If they were to go on contract only, then you can only claim medical costs, the wheelchair, the physiotherapist. In other words, you cannot claim on breach of contract for non-patrimonial loss. It will come clearer as we carry on. Okay, that was an introduction to get you into medical law. Now we focus on your first outcome, your first theory in your study guide that you should understand, and that is the Constitution of the Republic of South Africa. Please note how we write it. We do not say Act 108. There was another act that said when you refer to the Constitution, you do not refer to Act 108. Okay, just water. Okay, so I'm going to highlight a few things. I've already spoken about the right to equality, and I've spoken about the public sector and the private sector, and I've indicated that the public sector does not have a choice who they treat, who they get as patients, who they have to look after, whereas the private sector has a choice as long as it is not based on discrimination. So you must, the equality clause always keep the limitation clause. Section 36 of the Constitution must always be there. Remember that no right is absolute. It can be tested against the limitation clause, and then you will have to prove fair discrimination, etc. Then human dignity. Very important, Section 10 of the Constitution. As far as I know, I've never come across a specific medical negligence case where human dignity comes into play, but always test for it, always know that it is there, that human beings are entitled to be treated as worthy of respect and concern. In other words, we are speaking of the dignity of the patient, the dignity of the family of the patient, because no person is an island, dignity for staff and your colleagues, but also dignity for yourself. And dignity, keep it at the back of your head, goes hand in hand with informed consent. If to give a person enough information to make a decision is to respect his or her dignity. So just remember that it is not just the patient, it's also the doctor, the patient, the family, the workers. And at the end, you need to have dignity for yourself as well. Okay, the right to life, Section 11. Very, very, very important in a few scenarios. So I'm going to ask you, the Constitution say we've got a right to life. Do we have a right to die? Do we have a right to die? No, we don't. We don't. And in this sense, you must please take note of a living will. Some people will say, yes, but they have stipulated in their last testament and will that they do not want to be on machines, etc. A living will has no legal stance in the South African legal system, meaning you cannot go to court on the basis of a living will. A living will is only an indication to your family when you are in a position that you cannot take decisions yourself to help them to make a decision, but it cannot be a direct direction given to them, and if it is not followed, you can go to court. So you must remember that a living will is not a legal document in the South African legal system. It is just a directive. Okay, now, if we speak of the right to life, then death comes, and we have to speak about euthanasia. Euthanasia is when you help someone to die. Now, euthanasia can have two forms. You have active euthanasia, that is where you will inject someone with too much morphine and you know he will die and he died. That is active euthanasia. You took a step and you helped this person to die. Then we have passive euthanasia. Passive euthanasia is when the doctors see there's no hope for this person and they just do not give anything except painkillers. So they do not feed the person intravenously anymore. And it's just a matter of time, then the person will basically die. In other words, you see that it is hopeless and you just withdraw. And that is passive euthanasia. But then there's also something like physician-assisted suicide. That is where the doctor gives you a prescription and the doctor's with you when you then basically take your own life. Now, all of this is illegal in South Africa. We do not have a right to die, but you do have a right to refuse treatment. In other words, although you do not have a right to die, you can say you do not want any treatment. In other words, you are diagnosed with cancer, and the doctors say if you do not go for chemotherapy, you will die within 3 months. You have the choice to say, well, then I die. I do not want any treatment. Okay, so as long as you know that a living will is not a valid legal document, it is only a direction. As long as you know we have a right to life, we do not have a right to die. Other countries, in Oregon, the state of Oregon in the USA, and in Switzerland, they do follow physician-assisted suicide. In Switzerland, any person can go. You needn't be a Swiss citizen. In Oregon, the state of Oregon in the USA, you need to be a citizen of the state of Oregon. But you can go to Dignitas in Switzerland, and if you can prove that you are terminally ill and there's nothing that could be done for you anymore, then a doctor will be at your side and you will end your life by taking a prescription that the doctor gives you. We are fighting in South Africa to get euthanasia legalized or physician-assisted suicide, and you will read the detail in those cases that I've highlighted there, because a lot of people argue that it is undignified to be in such a state that you cannot look after yourself or to be in so much pain. It is undignified to keep a person alive. A lot of people have the argument that when our dogs or cats are in pain, we take them to the vet and they are injected and they go. Why not? Can't we do the same with human beings? But it's a debate that still goes on. And you can read the detail in those two cases. The first one, Stransom Ford versus the Minister of Justice and Correctional Services. It was 2015. He asked to be allowed to be assisted to die. Unfortunately, he died before the judgment was given, and judgment was given in his favor. And then after his death, the Minister of Justice went to the Supreme Court of Appeal. And there you can see the parties have now turned around in 2016. And in that case, it was once again said that euthanasia is illegal in South Africa, as is physician-assisted suicide, and a lot more research needs to be done. The other case that I highlight there is Carter versus Canada. That is where Canada decided to allow physician-assisted suicide in 2015. So in their country, it is now allowable. You will not be tested on these court cases. It is just for those of you interested in euthanasia or the debates around it. You can follow those cases. You can go and read it and then make up your own mind whether you agree or disagree, but it is basically on the basis of a right to life, a right to dignity, and then that we do not have a right to die in this country. Okay, then the Constitution, equality. Remember, I said that you cannot discriminate. There's also an act to keep in mind, the Prevention of Unfair Discrimination Act. And then what is very, very important in in medical law is Section 12. Very important. Freedom and security of the person. Because in Section 12, every person has the right to bodily integrity, and that links once again with the principle of informed consent. So later on in the next webinar, when we're going to discuss informed consent, we're going to refer back to this Section 12 of the Constitution, where everyone has the right to give permission for medical interventions and even research. And then the right to privacy. The right to privacy is Section 14. If you go on the HPCSA's website, you will see there's a booklet specifically on the right to privacy and confidentiality. Now, this is very interesting. Those of you who are legal advisors to hospitals, etc. Nowadays, and hospitals have contacted me, and they basically do not know how to handle the situation. You get the patient, let's say in ICU, and then the family comes to visit. But the family then starts paging in the file and even taking photos of the file or the chart. If the person is in ICU, there's usually a big chart at your feet that indicates your urine and your blood pressure, etc., etc. And then the family members will take photos. And hospitals have contacted me and asked, what should they do? That is absolutely, absolutely no, no, no. They have no right. It is between the patient and the doctor, or the patient and the hospital. And if you see, as a nurse or a doctor or just a normal citizen, and you see someone taking photos of either the file of the patient or the chart at his or her feet, report it immediately to management, because that is a complete violation of privacy, and it should not be done. Then the right, very important, look at the words of Section 27. The right to access to healthcare. In other words, you do not have a right to healthcare. Every citizen in South Africa only has a right of access to healthcare. And those of you working in that scenario where there's limited resources, etc., please read the constitutional case of Subramani versus the Minister of Health, KwaZulu-Natal. In that case, Mr. Subramani, he had renal failure. His kidneys were not functioning well. Unfortunately, he had other illnesses as well. So he was in the private sector and he was on dialysis, the machines that helped his kidneys to work. Eventually, his medical aid and all his finances was diminished, so he went to the public sector on the right to access to healthcare and said the public sector must now assist so that he can get dialysis. And then the hospital said in KwaZulu-Natal, they cannot accommodate him on dialysis because he is not a transplant candidate, because he's too old and he has other illnesses apart from his kidneys not working. And due to a lack of resources, the public cannot accommodate him on a dialysis program. They only have so many dialysis machines, and there are other patients to be accommodated there. Mr. Subramani cannot. And then Mr. Subramani went home and died. So this case is extremely important, not so much for the sake of dialysis and what. It is because in this case, it was said that if the state lacks the resources to help someone, it is a valid excuse not to help the person. And sometimes I think to myself, they're getting away with too much, too easy to say, but we cannot help because of lack of resources. Remember, every person has the right to emergency medical treatment. So this is now something different. This was not seen by the Constitutional Court as an emergency. But yes, they just didn't have the resources. He couldn't be on dialysis and he died. And that doesn't sit well with me, but go and read the case and remember, because you are going to come across a lot of cerebral palsy cases where babies are born disabled because of the negligence of the staff or the doctor. And then if it's in the public sector, the doctor or the staff will say, but there's a lack of resources, and they will refer back to this case. Okay, if ever you come across anything with children, you must remember it's section 28, but, be careful with children, because you have to look at the Children's Act as well as the Choice on Termination of Pregnancy Act. So according to the Constitution, a child is up to the age of 18. But according to the Children's Act, a child of sound mind who understands what's going on can consent to medical treatment and even an operation at the age of 12. In other words, if there need to be an operation and the child is 12 or older, that child, him or herself, must consent to the operation taking place. And if the parents do not want to give consent, the child can give consent. If, of course, he or she is of sound mind, mature, and understand what's going on. But remember, when you work with children below 12, be careful. Above 12, be careful. And then above 18, then it's not children anymore. Always keep this at the back of your mind. Then access to information. This is a huge problem. And a lot of times when I teach attorneys on medical law, then they tell me their biggest problem is to find records, hospital records. To get hospital records is extremely difficult. But you must remember that there are acts to help you to find these records. And that's why I would like you to buy that book of Van der Heever and Lawrenson on expert witnessing, because they tell you all the steps you have to take to get the hospital records. Because in medical law, if it's not written down, it did not happen. And unfortunately, in the public sector, records can disappear very quickly. Unacceptable, but you can insist on the records by using the Promotion of Access to Information Act. And I give you there the Unitas Hospital versus Van Wyk. It was a Supreme Court of Appeal case, which you can read and which will also help you in the process of getting hospital records. Okay, there I have listed some. Remember, it is our first outcome, so we're basically focusing on the Constitution. So there I've listed cases of importance. The first one is Subramani. As I've explained to you, it considers the lack of resources. The Tshabalala Mzimang, that is a violation of her privacy when the newspaper printed personal information about the former minister Tshabalala Mzimang. H versus the Fetal Assessment Center, very interesting case. We will come back to this one if we discuss the different birth issues in medical law: unwanted birth, unwanted pregnancy, and unwanted life. And in this case, the Constitutional Court said that we can claim on the basis of unwanted life. But I will refer back to this later in the next webinar. Lee versus the Minister of Correctional Services. It is a lengthy case, but it addresses causation. It is a guy that went into prison and then contracted TB. And the whole explanation how causation should be proven. Opelt versus Head Health of the Western Cape. Very, very interesting case. If you've got nothing to do on a Friday or Saturday evening and there's nothing on Netflix or whatever you watch, read this case. It is absolutely sad. And the good thing about that case is that you will see different expert opinions. Remember, you've got the judge, who is like a referee. You've got the applicant, the claimant, with the legal team and the experts. And you've got the defendant with the legal team and experts. And now both experts give evidence. How does the judge decide which one to believe? And what is sad about that case is that my heart goes with the minority judgment. But you decide for yourself. Then MEC Health and Social Development versus DZ. Very, very, very important case to take note of. There are other cases. I will refer you to that. And that there the challenge was on the once and for all rule. Remember, when damages are proven, then it must be paid in a lump sum in money once and for all. And in that case, that was challenged. And the outcome of that case is that nowadays in medical negligence claims, you will not be paid a lump sum. You will be paid as when it is necessary. You will also not get an amount for future medical costs because the medical services will be provided free of charge to you. So that was the beginning of that whole change in medical law concerning the payout of damages. Then if you are interested in road accident fund cases, we do not focus on those in this module, but then you can go and read that case of the Minister of Transport and the Law Society, and you can also read the case of Ronald Bobroff, and that will give you some guidance in road accident fund cases. Now, these cases, the judgment have not been given yet, but I want you, when you have time, again, as I say, if you've got nothing to do on a Sunday afternoon, sorry, I'm just drinking water, before you become blue and lonely, go to the Constitutional Court's website and go to they've got 3 tables there. The one is the recent judgment. The middle one is forthcoming judgments. And then the other ones say recent hearings. And what is absolutely phenomenal, and I absolutely love this, you can now watch the whole court case. So you can click on the link and then you go back to that day and that whole court case. So I would love you to go and watch the YouTube video of NVM versus Tembisa Hospital. It is not long because remember, in the Constitutional Court, it is very short. Every party has 10 minutes to state their case. The justices have the right to question, but it is not long. It is, let's say, half an hour, 40 minutes, maximum an hour. But you're going to love it to hear the arguments, to see how the justices react, the questions they ask, and you will learn so much. So if possible, go and watch that judgment on YouTube. The judgment has not been given yet. So the final judgment is not out. The same with the next one, the MEC for Health versus TM on behalf of MM. That case went to the Supreme Court of Appeal, And it was successful there. And then they approached the Constitutional Court. You can also watch the YouTube video. You can hear the arguments. Extremely entertaining, interesting, because it just opens everything up for you. And then the last one that you can also watch on the YouTube video is the voice of the unborn baby, NPC versus the Minister of Home Affairs. Now, I was personally involved with that case, and we are waiting for the judgment. What that case is basically about, according to the Birth and Death Registration Act, if there's a miscarriage, in other words, the mother loses the baby for before 26 weeks that she was pregnant, it is automatically medical waste and it goes to the incinerator. If there's a miscarriage after 26 weeks of being pregnant, it is seen as a stillbirth, and a completely different process is followed, and that fetus can be buried, and the parents can get closure and have a ceremony. But before 26 weeks, you're not allowed to take what is left of the baby home and have a ritual. And we are arguing that it is unconstitutional and it is not fair, that every woman should have the choice whether, even if she has a miscarriage at 20 weeks, whether she wants a ceremony, a burial, a cremation, let it be her choice, because there's no cost implication for the state, etc., etc. But we have argued it. You can also watch that video, and we are awaiting the judgment for that. Very, very interesting. Okay, now I'm going to touch in as anticipation for our next webinar. I'm just briefly going to speak about the doctor and the hospital and the patient's relationship. As I said, you can sue on the basis of a contract, a delict, or both. What are the requirements for a contract? There must be consensus. In other words, I go to the doctor, I say I'm sick, he says he has the knowledge, he will treat me, we have consensus. I'm above 18, I have the capacity to act. Or I'm above 12 with the necessary maturity. It is physically possible, he has the ability to treat me, I present me to him, it's physically possible. It's legally possible because he's registered as a doctor and therefore he can do what he has to do. And then damages if necessary. Okay. These are the contract. Now, if you want to see how a contract was applied, then you can read the case of the administrator of Natal versus Edward. These people had children. They fell pregnant again after a failed sterilization, and then they sued the hospital on the basis that they broke the contract. Now you will see it's an old case. It was before the New South Africa, 1990. Then we did not have the 9 provinces. We had the 4 provinces, and the head of the province was the administrator. So that is where it comes from. Administrator of Natal, public sector, and it is this couple that sued the public hospital because of a failed sterilization, and they claimed the upbringing cost for that baby, and it was allowed in the Supreme Court of Appeal. The mother could not claim pain and suffering for the pregnancy because they only sued on the basis of a contract and not a delict. Then what are the requirements for a delict? As I've said, conduct, wrongfulness, damages, causation, and fault. That is just a repetition of what I've said. And then I want to highlight the Afrox case. If you go and read that case, I apologize from the start. That case is only reported in Afrikaans. I don't know why, but you cannot find a reported case in English. But if you Google Afrox versus Stradum, you will get a lot of English summaries. That case concerns a hospital. Life Hospitals, as we know it today, their previous name was Afrox. And in that case, Mr. Strydom went to hospital. The hospital contract that he signed indemnified them against any negligence. He refused to sign it. They said he has to sign it, otherwise there's no contract. And then he took them to court on this exclusionary clause. Unfortunately, the Supreme Court of Appeal gave judgment in favor of the hospital and said that these exclusionary clauses in hospital contracts are valid. And it still stands up till today, which is completely unfortunate. With the new Consumer Protection Act, the hope is that another patient will take a hospital to court with their exclusionary clauses, and then that the court will change the whole scenario. But until that happens, the Afrox and Strydom case is still the precedent that stands because it's a Supreme Court of Appeal judgment. So you should take note of that. Okay. Do a doctor have a duty to treat? Yes and no. As I've said, in the private sector, he or she can choose. In the public sector, they do not have a choice. But once they started with the treatment, they have to complete it. They cannot just abandon their patient, because then they can be sued for negligence. Okay, do they have a duty to get informed consent? Yes, yes, yes. According to Section 12 of the Constitution, and also Section 6, 7, and 8 of the National Health Act. According to the Consumer Protection Act, you can read the booklet of the Health Professions Council on informed consent. And then I've quoted their two cases, Isaacs versus Pundy. That was in the High Court, and then it went on appeal, so the parties changed, Pundy versus Isaacs. It concerns informed consent for a sterilization. Very important that for a sterilization, you need written consent. For all other contracts can be oral, it needn't be in writing. But for a sterilization, the Sterilization Act stipulates that consent must be in writing. And then the other one, RB versus Smith, that went to the Supreme Court of Appeal. It was he said, she said, the doctor could not really prove the records he made and whether the patient gave informed consent. She said she did not give informed consent, but the Supreme Court of Appeal gave judgment in favor of the doctor. But you can go and read that on yourself. Okay, I've said a delict is that there is a duty of care, and it must be towards a certain standard. Okay, then some students have asked questions in the past whether the standard of care test of a reasonable doctor can ever be objective. Not really, if we were to philosophize about that, but as we teach you medical law, we speak of an objective test. The reasonable doctor is an objective test. We can go into detail and reason, but for the sake of theory, accept that the reasonable doctor test is considered to be an objective test. And then a preponderance of probabilities is the same as a balance of probabilities. It's just different words. So in a civil case, you have to prove the guilt of the party on a balance of probabilities or a preponderance of probabilities, whereas with a criminal case, you have to prove it beyond reasonable doubt. And that is it. So let's take away my share. Okay, and I'm going to put on my camera so that you can see I'm a living person. And now you are allowed to ask any question that you want to. If you are in a hurry and you want to leave, you do not have to apologize. You can just go. So I don't mind. Thank you for attending. And as I've said, the slideshows will be available tomorrow. I will send it now when I'm finished to Bonnie, and it will be on your web page. But anyone, you can just raise your hand. Otherwise, just unmute yourself and ask. Okay, first one, Sipho. Let's hear.
Yes, hi everyone. Hi, Prof. Thank you for the lovely session. I'm just trying to go back on the notes over here. Earlier on, you spoke about, so you touched upon something, and it was the distinction between a private hospital and a public hospital. So, it was a certain standard. I'm just trying to find it on the notes, but essentially, I was just thinking because with what you're saying in terms of the budget allocations for public hospitals, surely in a private hospital setting, um, doctors can't rely on what doctors in the public sector rely on in terms of lack of resources. So surely it would be more difficult for doctors in the private sector to disprove negligence on that ground. I think you touched upon a case where it was a private hospital that relied on that. Sorry, I can't find it now. Could you speak to that a little bit, if you don't mind?
Okay, as far as I know, there's no private hospital
Mhm.
that can say there's a lack of resources.
Mhm.
They will not, that will not stand.
Mhm.
So it will once again depend on the specific cases. Remember, in a private sector case, it depends on whether the negligence was for the hospital or for the doctor. I'm going to give you an example. My hairdresser is a very small built young woman, and she has some or other blood deficiency. So she fell pregnant against what the doctor advised. But anyway, the day came that she had to give birth, and everyone was there. A surgeon was there, a gynecologist was there, a hematologist was there to look after the blood. All possible specialists was there. The nurses were prepped. So they delivered the baby, and then the woman had a shortage of oxygen, and they put the oxygen mask on her only to realize there was no oxygen in the cylinder. And it was a private hospital. So eventually one of the specialists jumped on her and did resuscitation mouth to mouth and she survived. She survived. She was fine. The baby was fine. Of course, then they could not sue anyone. But now the question is, who should have checked that the gas cylinder was full? In that instance, the private hospital will never, ever succeed with a lack of resources. So I cannot think, and if it's in your notes, you must please notify me, because then that is a mistake. A private hospital will never have the justification that there was a lack of resources. The problem with the private hospitals, and I'm going to deal with this in detail in the second webinar, who's in charge, because all the doctors are independent contractors. So who is ultimately the head of the team? That's a gray area with no answer in our legal system. But if you find the place where I said private hospitals can have the argument of lack of resources, please speak to me again. It's only public hospitals and clinics
No, I
that
see.
can argue a lack of resource. Yeah.
It
Okay.
was a quote from the judge in the Mediclinic versus Vermeulen case. So it was implied, where it said everything that goes wrong is not to be considered as being negligent. So it's that
Yes.
I suppose I read into it and it was implied,
Okay.
but
That is an interesting case for you to go and read, because this person had bed sores, but he was huge. He was huge. and the nurses tried to move him, but he was not helping them, and eventually the bed sores just became so bad, and then he died. So they didn't argue a lack of resources. They basically argued the nurses didn't do their work, but the nurses did their work. But it was, in a certain sense, impossible, and he did not cooperate. But it's an interesting case to go and read. Okay, let's see, Tony. I see your hand is up. Yeah, Tony, you must just unmute yourself.
Oh, sorry.
Now I hear. Yes.
Good evening, everyone. Nice. Thank you, Professor. I will say Professor. Thank you very much.
Thank you.
My question has to do with the activity that I saw and the case. They say the sources is a case there, PG on behalf of TG MEC. I'm struggling with that case. When I try to Google or find that case, it's coming up with something that is a bit different. So I don't know where I can straight.
Okay, so you wrote the email that Grace forwarded to me.
I don't think so.
Well, no. Never mind. Anyway, I checked with Bonnie. Bonnie uploaded the activities and she forgot to add the cases. So if you go to your website now, you will see the reading material for the case. And you don't have to read wider than the case. I think there's one activity what is based on organ transplants where I say you can go consult the National Health Act, but they also quote the act in the case. So I don't expect you to go wider than the case. All the answers will be in the case. Okay.
Thank you very much, ma'am. Thank you.
Right. Okay, let's see. Bernard Dippenaar.
Hello, Prof. Thank you so much for the talk.
Yes.
For the lecture. You've no doubt seen the recent cases in the Labour Court about dismissals and fair dismissals regarding the taking of vaccines. Yes. I know this is quite a contentious issue, but after reading some of those cases, I just have a bit of a issue, and please don't take this as me being against the vaccinations. I myself have taken it, but I have a problem between the interplay of bodily integrity and the limitation clause, because in my opinion, I even listened to some seminars of some of the virologists, and even they have admitted that they don't understand the full implications of taking these vaccines at this time. So in light of that information, how are our courts finding in favor of forced vaccinations? I struggle to see that link between their decision and the reality of the information, the incomplete information about these vaccinations.
Bernard, I'm not an expert, so I'm also going to say there's a lot of people who see this whole COVID and vaccination issue as a medical trial. And some even go as far to say it resembles the Nuremberg trials, that basically all human beings are participants in an experiment. So I have a personal feeling, but that is of no interest. The difficulty with the courts is that no one was prepared and no one really knows. So I think everyone just follows their own reason. But you must remember, under a state of emergency, different rules apply. So yes, I agree with you, bodily integrity, but the limitation clause comes into play within a state of emergency, and to weigh all these things. And it will depend also on the specific work that you do. For example, if I completely refuse to vaccinate, I work at home nowadays. I sit in my own office. I only see my husband and my domestic worker, versus a nurse versus a teacher that works with 40 or so many children, or a receptionist working with a lot of people. So all these things come into play, but honestly, I don't have an answer for you.
Okay, no problem. I think that's everyone's answer. They don't know at this time. Okay, thank you very much.
Okay, let's see, Etumuleng. Etumuleng, you can speak? Yes.
Yes, hi.
Nice seeing everyone. Yes.
Hi, Prof. Thank you so much for a very, very
Yes.
informative session.
A lot of information.
Much appreciated. It's smacked the ignorance out of me on one or two issues as things stand. But my concern is with the discussion that you had on the Vermeulen case. In my mind, and perhaps this is why I've now taken this course to be disabused of my ignorance, but in my mind, you walk into a hospital, you walk out with an amputation, somebody has to pay. It can only be, and that is the basis from what I was operating on.
Yeah.
And this is what I understood as a DV versus Tembisa Hospital case that's we all now waiting the judgment in a constitutional court to be about, where I think if I recall the facts correctly, is that the hospital should have monitored the pregnant woman every 3 hours, but they were negligent in not monitoring her for a period in excess of 3 hours. And as a result, there was a sudden rupture and a child was born with a brain injury and. But under those circumstances, where there are no, is it ECG machines or something that they call them, where there are no such machines available to ensure that there's proper monitoring, how then do we hold the hospital negligent under those circumstances?
Okay, once again, I'm giving general information. It depends on the circumstances, but nurses are also taught to listen with something that looks like huge and then thin. Yeah, but they are taught different ways if technology is not there. So you can't really compare not that you compared the two cases. Let's quickly speak about the Vermeulen case. The Vermeulen case, if you go into hospital and you walk out, for example, legs being amputated, it is not necessarily negligence. You must always remember that medicine is not an exact science. In other words, no doctor, no hospital guarantees that you will be cured. So every person's body can react differently to medication. You can react differently to the anesthetics. They could do everything possible and you can still die. Or they can do everything possible and you can still lose your arm. It depends on so many variables, and that is why in the next webinar we're going to go into detail how to determine negligence. In the Vermeulen case, as I've said, that the guy was huge. He was obese and he had bed sores, and it was difficult to move him continuously to avoid the bed sores and all those things. So you cannot just then assume or take it for a fact that the nurses were negligent because he died of septicemia of bed sores, which should not happen, and it usually doesn't happen, but this was unique circumstances. Then let's go to the maternity wards. And this is a good topic if one of you are thinking of doing a master's or a doctorate. I would like someone to take all cerebral palsy cases and see how different courts entertain them and how different experts are, etc. But yes, that is a huge problem in the public sector. If they did not have the machines, it will depend on whether there was a protocol in place that if something like that happens and there is distress, to move the woman to a nearby hospital. That is one option, via ambulance to a nearby hospital who would be able to monitor it, or to call a doctor who will then give advice on the way forward, or as I've said, they were taught to monitor the fetal heart rate without some of those machines. The fact that they did nothing, that's where the problem is. If they tried something, it would have been better. But I'm not going to go into full detail. Otherwise, in the next webinar, I've got nothing to say. But keep on thinking. And as we have the next webinar, I will discuss certain topics, and then some of your questions might be answered, or you can ask again and again. Okay, let's go to Karel. Karel, your hand was up. Karel de Tooy.
Good evening, Prof.
Yes.
I should say good morning because I'm joining you from Alberta, Canada.
Oh, wonderful.
Yes, so here it's still 8 minutes to 11 in the morning, so a whole day is still ahead.
It's in front of you. We've done the day.
Yes, if there's anything I need to look out for, please let me know. Thank you for a very interesting webinar. I've really enjoyed it. This is not a legal question. This is more a course question. You mentioned that you would be sending out the slides that would be placed on is it in the forum folder? Is that correct?
I'm not sure where Bonnie places it, either announcements or forum. Yeah.
And then will the audio recording also be included? Not. Okay, so if we have any questions.
Unfortunately, that is the policy of LEAD, that they don't provide the audio, because otherwise then the people do not attend the webinars. There's no interaction because they do it at their own leisure. But the PowerPoint, I've got no problem if that is distributed.
Okay. And then just a follow-up question, the court cases. You said that would be provided. Obviously, in my case, that'll help a lot because I'm not close to any legal library. Will that be placed on the forum, or do we need to request it as needed?
No, it will be placed on the forum. If I'm correct, Bonnie notified me she has already uploaded it under reading material for activities, something like that. Yes. And remember that if I put extra reading, it will all be there. But if you, for some or other reason, one case tickles you and you would like to read it, you can just ask me and I will send it to you. Okay, because otherwise I just, like that list of cases, I just give the list and then everyone at his or her own pace can go and read it. But if you want something, I can always forward it to you.
Baie dankie Prof, geniet die dag hoor.
Okay. Ishmael. Bruce, I'll be with you just now. Ishmael.
Hi, Prof. Good morning or good evening, everybody. Okay, so my question has a bit to do with the statement earlier that a private hospital can never say or never use the defense of a lack of resources. Right now, I obviously understand where the case law comes from in that, and I understand where the reasoning comes from in that. Where I'm finding a little bit of difficulty with that now is just the pandemic that we've just come through. So, I mean, let's say I show up at a private hospital with COVID symptoms, I get admitted, the doctor takes responsibility for me. 2 days later, my condition deteriorates completely and I need a ventilator. But there are 100 other people on ventilators and the hospital just doesn't have. They have none available and they cannot get any more because you've got 1 million people on ventilators across the country. 12 hours later, I'm gone. I'm the sole breadwinner and my family now wants to institute a claim. But it's not because the hospital didn't want to. It's not because the hospital was negligent, but they did not have the resources. So I do think maybe in a situation like that, that defense could be raised.
Excellent. I just didn't think about it. That could. But remember, those are rare circumstances and in a pandemic. But yes. Thank you for that comment.
I'm happy. Okay.
My mind
Thank
went like this. I never thought about it. Yes.
Thank you, Prof.
Comment. Okay. Bruce, you wanted to say something?
Thank you, Prof. Thank you very much for the very enlightening lecture. I come from a total different background, being an aviation law specialist, having been a military lawyer and coming back to the profession now, but also having a lot to deal with the medical side of the military and giving advice in that regard. Now, I just want, my question is not law related per se, except for just wanting to understand that I'm correct in assuming that when you say we need not worry with any referencing, does that mean for me that I need not then cite the paragraph number and or the page on which the information is found? You just basically then give the answer straightforward.
Yes, yes, and yes, because the reason, as I've said, it's like a comprehension test. You were at school many, many moons ago, but in a comprehension test, I want you to read the case, because even I ask stupid questions, but that is to force you to read it. But I want you, once you've read it and you've answered the question, to sit back and say, do I agree or not? What just happened here? Because the cases that I've selected, each one is going to bring something out that you might never have thought about, or you might completely disagree or whatever. But it is things that happens in practice and was not necessarily covered in theory. But Bruce, personally, please send me an email with your particulars, because in the previous class, there was another person also in aviation law. And I think if you two connect with each other, that will be good for both of you, because he sometimes asks me questions and I'm not an expert in aviation law, but what he does is the overlap between medical law and aviation law. For example, the test that pilots go through, or that the pilots are fired because of taking some medicine or whatever. But I'm no expert in that area. But if you are interested, send me an email. I will put you in touch with him, and I think you will just be good for each other.
No problem. Thank you very much. I will indeed do so. Up until the time that I retired from the military, I was the Chief Legal Advisor to the Chief of the South African Air Force. So I know everything about pilots and aviation. So I'll be able to assist in that regard.
Perfect. Yes.
Thank you very much.
Thanks,
Thank you.
Okay. Tony, just you can ask. Tony, have I answered your question? Or
Yes, you have answered my question, Ma.
Okay, so it's a historic hand.
Right.
Ishmael, you want to say something? You okay? Also covered. Anyone else? We just go quickly see. Okay, people. Yes, I think you have a lot of questions, but remember, this was now you've given the first step. You must now go and read the theory. Be prepared, do test 1. And then remember, there's a second and a third webinar coming up, and we will go in much more detail. And I will also ask Bonnie to upload certain articles that I find interesting, or certain cases. But for now, focus on your test 1. And if you can, listen to those cases in the Constitutional Court. It is very, very interesting. Okay, any urgent question or the hands from the past? Okay, then I'm going to end here, and thank you to all of you who participated and do listen. I spoke a lot. It will take time to digest, but yeah, I hope you enjoy this webinar, and I see you at the next webinar. Have a good evening. Bye.
Bye, Prof.
Thank you.
Bye, Prof. Bye, Prof. Thanks. Thank you.
Bye.
Bye-bye. Thank you, Prof.